Good afternoon, everyone, and thank you for joining us. Please welcome Katie Glenn Bass.
Hi, everyone. I'm Katie Glenn Bass. I am the Research Director at the Knight First Amendment Institute. Welcome back for the second and final day of the Data and Democracy Symposium, co-sponsored by the Knight Institute and the Law and Political Economy Project. We have a great lineup today. Our first panel, starting in just a moment, looks at data publicity and public control, followed by a keynote at 1:40 p.m. by Julia Angwin of The Markup, and then wrapping up the day with a panel on engineering access to data and algorithms at 2:30. Right now, it's my pleasure to introduce Paul Ohm, our very capable moderator for the next panel. Paul is a professor of law at Georgetown. He is also their Associate Dean for Academic Affairs and their Chief Data Officer, which I have to assume means he's been extremely busy since March of this year. Paul, welcome. Thank you so much for being here, and please take it away.
Thank you, Katie. I am so happy to be with you. When I was invited to the Data and Democracy Conference, I hurriedly wrote in my notes that I got invited to the Knight Institute D&D conference. And so I will be your dungeon master, and I've prepared a hobgoblin raid on Baldur's Gate, but I think we should go with the original program after all. The most important thing I want to say at the outset is that although we're going to have presentations from the panelists, I do want this to be as interactive as humanly possible, and that starts with you, the audience. And so you'll notice at the bottom of your Zoom control that there is a Q&A button, and that's what we're going to use to solicit questions from you, which then I will channel as your avatar and ask of our wonderful panelists. So please ask questions early and ask them often. Let me lay out some of the ground rules before I turn to our amazing panelists. So we have 3 different papers and a discussant for today's session, like the format for yesterday. Each speaker will speak for 7 minutes. I have told them that I will be a ruthless dictator when it comes to controlling the time, because I want to make sure that we do have a lot of time for discussion. If you hear me just coughing inappropriately, that means your time is up. After the 3 papers, we'll have a discussant, and then that will leave us 1 whole hour for discussion amongst ourselves. I'll take moderator's privilege and lead some of the early discussion, but I will bring in your questions as often as possible. I will dispense with detailed biographies. You should assume that these people are luminaries in the field. They really are. Every one of them has well-deserved accolades, tons of publications, important books, fancy affiliations. Assume it all, or go to the website and click on their links for their detailed biographies. But instead, I'm just going to highlight the high points. Our first speaker, I'm glad to welcome, is Rebecca Wexler, a professor at the University of California, Berkeley. She works on issues concerning data, technology, and criminal justice. Rebecca?
Paul, thank you so much. And thank you to Katie, Jamil, the Knight Institute, Amy Kopczynski, and Paul for this wonderful symposium. It's thought-provoking and mind-expanding. I'm going to start with a story about GitHub and the death penalty. A Texas death penalty inmate is trying, as we speak, to get access to source code in a forensic software program used to convict him. The judge found the code to be material and necessary for the administration of justice and ordered the company that produced it to disclose it under a strict protective order. But the company, which is located in New Zealand and beyond the court's jurisdiction, refused to comply. That left the defendant trying to seek the code from a US company, GitHub. But GitHub relied on a key data privacy law for the internet called the Stored Communications Act, or SCA, to again deny the defense subpoena. Now, police or prosecutors seeking that exact same information could have compelled it from the company in New Zealand using a mutual legal assistance treaty, or they could have compelled GitHub to disclose it using a special law enforcement exception to the SCA. But under current law, defense counsel is categorically prohibited from using either of those investigative routes. This case exemplifies why the 20th century synthesis, the notion that economic laws that govern markets are distinct from public laws that govern democratic functions. This case exemplifies why that 20th century synthesis blinds us to the need and opportunity that new data-driven technologies pose for law and democracy. In this one death penalty case, the administration of the criminal process has become partially privatized. And as a result, private economic laws like intellectual property and data privacy laws can undermine the adversarial truth-seeking process of the courts. The law and political economy movement identifies and contests this 20th century synthesis and challenges us to respond not merely to private power, but also to acknowledge that it is legal orders that shape and are influenced and facilitate that private power. My essay for this symposium is the third in a trilogy of works. It builds on an initial article that I have called Privacy Asymmetries, identifying a trend in data privacy laws, which is that, as Julie Cohen's essay mentioned yesterday, they often include exceptions for law enforcement to access sensitive information, but they don't include parallel exceptions for criminal defense investigators. And that means that data privacy laws systematically favor the investigation of guilt over the investigation of innocence. The other paper that this essay builds on is called Privacy as Privilege, and it makes a doctrinal legal argument to try to fix this asymmetry in the SCA, arguing that silence in statutory text should be insufficient to block criminal defense subpoenas. So how does this relate to the global data economy? Well, my essay for this symposium applies both of those concepts to cross-border data flows. Beginning in the Reagan administration, the US government began to negotiate these mutual legal assistance treaties that facilitate law enforcement collaboration in cross-border investigations, but expressly barred defense investigators from using the same process. The rise of the global data economy is making that asymmetry worse for two reasons. First, more relevant evidence is digital and is possessed by third-party companies, and more of it can be stored abroad, not just in global criminal cases like trafficking, global corporate crime, or terrorism, but even domestic criminal cases where all the alleged conduct took place within the US. And the second reason is that foreign countries concerned about the erosion of privacy and of their sovereignty interests are enacting data privacy protection and localization laws that block off existing investigative routes outside the MLAT process. And so law enforcement has certain buffers against the erosion of its cross-border investigative power that defense investigators lack. It has the MLAT power, which I mentioned already, and it also has a new power under the Cloud Act of 2018, which enables the government to negotiate a new series of cloud agreements that are supposed to expand efficiency and surpass the MLAT process in cross-border investigations. The first of those agreements with the UK went into effect over the summer, and like the MLATs that preceded it, it provides for law enforcement access, but not defense access. The other buffer that law enforcement has also in the Cloud Act is that the Cloud Act makes clear that law enforcement can compel US companies to disclose data that those companies store on foreign servers, again, under the authority of the SCA. So my proposal in this essay is that we should interpret the Cloud Act to help fix the asymmetry. One of the things that the Cloud Act can do, if properly construed, and again, bringing in the doctrinal legal argument that I develop in full in Privacy as Privilege, is say that not just law enforcement, but also the criminally accused should be able to subpoena US companies like GitHub for data like the source code from the New Zealand company that the companies store on foreign servers. If our courts are unable to compel disclosures of material evidence that they deem necessary to the administration of justice in a death penalty case, then our courts cannot adequately check the power of the executive in the exercise of that most awesome power to take liberty or life. A democracy requires that check. Thank you.
Too many buttons to click. Thank you, Rebecca. That was wonderful. And astonishingly, you left 36 seconds on the table, so we'll make sure you get that back. That was wonderful. I'm proud to and happy to introduce our next speaker. Our next speaker is Frank Pasquale. He is a professor at the Brooklyn Law School. He's an expert on artificial intelligence, algorithms, and machine learning. Frank?
Thanks so much, Paul. It is terrific to be here. And I am really happy to get a chance to try out some new ideas for data protection with such a fantastic group, thinking about these ideas with a group that's thinking about them in the broadest possible terms. So a big thanks to our sponsors, Knight, the Law and Political Economy Project, others, and just a note of continuity in my presentation. I really enjoyed Julie Cohen's talk yesterday. As always, I always learn a lot, so much from her work. And she offered, I think, a very critical vision of the narrowness of current privacy laws. And I think part of my vision that I'm going to offer today is to look at a new tool for a very broad approach toward restructuring the political economy of data and trying even to develop an industrial policy for data incrementally through some existing tools and advocacy in that area. And part of my inspiration is a passage that comes near the end of Jill Lepore's book, If Then, How the Simulmatics Corporation Invented the Future. And toward the end of the book, Lepore describes early concerns in the US about things that were called people machines, these data collecting entities that were trying to collect as much data about people and to use them both in marketing and in politics. And Ithiel de Sola Pool was one of the people there who was very involved in this at MIT. And Newton Minow, who right before he became the chair of the Federal Communications Commission, looking at the potentials for data to manipulate individuals and have other bad effects in society, wrote to Arthur Schlesinger and said, you know, this seems like it's something that couldn't work, shouldn't work, and maybe should be illegal. And it was remarkable to sort of see the initial reactions and how over 60 years, how far we've come from those initial reactions. And I think part of what my paper is trying to do is to think about what does it look like if we take those reactions more seriously. So one of the ideas that I get across in my piece is that we can all imagine some forms of data collection, analysis, or use that are so sensitive that we would want the data controller or processor to demonstrate its capacity to do the collection, analysis, or use competently before it undertook that data collection, analysis, or use. Okay, and one example that I could give there, a very concrete example of data breaches. You know, I chair the Privacy, Confidentiality, and Security Subcommittee for the National Committee on Vital and Health Statistics. And one of the things that, you know, always was coming to my attention in terms of watching the news, watching developments there, is the deep problem with breaches, ransomware, ongoing in healthcare institutions. We have all heard of the Equifax breach, other breaches that have occurred. And it seems as though this is a problem that is deeply worrisome, and we may want to look ex ante rather than ex post at institutions' capability to secure their data. In terms of other issues, I mean, in facial recognition, there's been this really fascinating debate among leading thinkers in the area like Chris Gilliard, Alondra Nelson, Zoe T. Samudzi, about facial recognition being a deep threat. And Evan Selinger and Woody Hartzog have written an article about saying maybe we should ban it. My article comes in more on the level of what Luke Stark of Microsoft Research has proposed, which is to license facial recognition, to say this is like plutonium. We don't allow just any entity to have plutonium. We say that something that powerful, we know it can be used for amazingly good things, that, you know, some forms of radiation might be used to identify cancers, but by and large, we're very worried about the danger of it. And therefore, maybe we want to license facial recognition rather than just allowing any entity to do it. And so in saying that, I tried to generalize from Stark's idea and from other ideas about sort of licensing in these areas to say, it may be better to require a license before anyone doing large scale data processing or analysis accumulates a huge amount of data, you know, very large amount of data, possesses data with extremely important consequences and processes that data with extremely important consequences, or uses it for very important decisions. And I want to ask, you know, how far can we push that insight, perhaps even toward an industrial policy for big data? And my intuition here is that the larger the data collection or processing, the more we may be comfortable with a licensing regime. Here I'm building on some work I co-authored with Danielle Citron, and I co-authored called The Scored Society in 2014, where we talked about once an entity had, say, over 2,000 records, that there were certain levels of due process that would be triggered by that level of data collection when it starts making decisions about the persons who are the data subjects. And I think that licensing could be quite general or granular, permissive or demanding. You know, I'm not saying that this needs to be always so restrictive, but I think that after a critical mass of breaches, discriminatory practices, wrong or utterly opaque data practices, consensus will build towards some type of ex-ante licensing as opposed to ex-post efforts to punish troubling or illegal collection, analysis, or use. My last 2 points will just be that I've come to this position having looked at and engaged with consent-based models for many years, or at least over a decade, and just seeing how badly they have failed in the past and how hard it would be to implement anything that sort of would be realistic there. And also in terms of thinking about restricting data processing, collection, analysis, and use, how hard it is to do that ex post as well, given trade secrecy. I see that my time is up, but I very much look forward to describing and discussing the First Amendment implications of the proposal. I've done some thinking about that in the paper and would love to engage with the experts here because I know it's in many bailiwicks, and really appreciate this chance to bring this idea to the public and to our democracy. Thanks.
Thank you, Frank. I'm about to break the fourth wall and let you in on our backstage conversations. When you see my picture appear to speakers, that means you have 2 minutes left. It doesn't mean you're done, but Frank, thank you for that presentation. Thank you to the questioner. We got our first question. Please continue to submit questions and we'll get to them in the last part of the panel. So our next paper is actually a joint work, and during the Q&A, you will get to see both of the authors. Not pictured or speaking now is Martin Murillo, who is a researcher and technologist focused on the intersection of political science and engineering. You will hear from his co-author, Wendy Wagner, professor at the University of Texas School of Law, who focuses on the design of bureaucratic processes, environmental regulation, and law and science. Wendy?
Thanks so much, Paul. And thanks to the Knight Institute and particularly Katie and Amy for putting an amazing conference together and including us in it. So our paper is about the use of algorithmic tools in environmental and public health regulation. And in this domain, big data tools actually offer great opportunities for the public. They can be used to screen untested chemicals, to locate communities that face high levels of toxic risks, to help agencies with scarce resources actually prioritize the firms that are most likely in non-compliance. And that's just to name a few. But there are perils as well to the use of these algorithmic tools in regulation. We already know empirically that about half the rules promulgated by our environmental and public health agencies are devoid of any public engagement, including by public advocates. And in those rules, those half of the rules that lack public interest engagement, we actually can see distinct biases favoring industry and regulated parties as a result. So take this pre-existing problem and throw on top of it complex algorithmic tools. When they are used by agencies, they can serve to exacerbate and aggravate these pre-existing problems because they require so much expertise and time and resources on behalf of the public and the public advocates to really engage meaningfully in these tools. But of course, if there's no public engaged in the use of algorithmic tools for regulation, then we're likely to see regulated parties in particular have even more opportunities to dominate the regulatory process in ways that probably undermine and undercut our ability to see the authorizing legislation actually come to pass in terms of public health protection. So our paper just simply asks a simple question. Given this situation, is administrative law ready for these new algorithmic tools? And as you can see from my slide, from the perspective in particular of the public at large and the public advocates that attempt to represent them. We're looking primarily in our paper, obviously at environmental and public health, as I've mentioned, but also primarily at agency rulemakings, because those are the most circumscribed legally. where we actually expect the very best results in terms of democratic deliberations over those rules. So our findings in a thumbnail sketch are that administrative law is not terribly ready, and there's a lot of room for improvement. In fact, there's a distinct mismatch between what administrative law wants to do with regard to democratic deliberations and engaging the public, and what administrative law actually encourages agencies to do. And in fact, our findings are slightly worse. Cumulatively, administrative law isn't just agnostic, essentially, on ensuring rigorous public engagement and oversight. Oops, I think we're going through too many slides. Sorry, guys. You can back up to that first very boring one, if you don't mind. But that was a good idea to think that I was at that point. So there's a mismatch between what administrative law essentially wants us to be doing with public and actually what it is encouraging the agencies to do. And what's worse is actually agencies are tacitly rewarded in some regulatory settings for bypassing inclusive public deliberation. So now, next slide, our paper unfolds in 3 parts, and I need to obviously march through those, and I will at a high altitude level. So the first part is the theory part. And in this part, we try to conceptualize for these complex algorithmic tools, how do we include the public? This is an just synthesize the existing literature academically, and also a very helpful National Academies report to extract what we essentially call best practices. These best practices tell us how we should engage the public in creating these algorithms. And it really involves 2 things. First, the developer of the tool needs to show their work. They need to explicate each of the steps of developing the algorithmic tool, beginning with even whether to use one at all, and engage both public and experts on each of these steps. All the way from whether to use the tool to obviously what kind of assumptions would it use, all the way to how do we ensure the tool is really useful to public policy and that it's providing outputs that are rigorous. So part 1, the theory part, basically gives us what administrative law ought to look like for the use of these algorithmic tools, how we should be engaging the public. And we use that essentially as a template or probe to compare against the is, what administrative law essentially is encouraging agencies to do it. And this is where we see the mismatch. Essentially, rather than encouraging agencies to embrace these best practices, to break down their work, to bring the public and experts in at each key step, it's leading us essentially in the opposite direction. Okay, next slide, please. So we have a lot of different ways in the paper that we suggest that administrative law is leading to these perverse effects. Obviously, you don't have time to go over all of them, but I just want to highlight a few for illustration purposes. The first is, in administrative law, there's actually no requirement that an agency's proposal for public deliberation is comprehensible. If the agency wants to publish a 100-page preamble to its rule, with dozens of background documents that are linked in the rule that require stakeholders who care about this process to spend months trying to make sense of it, that's perfectly fine in administrative law. It puts it on the commentator's shoulders, including the public and the advocates, to decipher all the choices and the decisions that might be embedded in, for example, a complex algorithmic tool. Indeed, perversely, if the agency actually did unpack all its work, it's setting itself up for more litigation, more attachment points, more things for litigants to essentially call out and challenge in court. A second example, under the Administrative Procedures Act, agencies are required to give the opportunity for the public to comment on the agency's proposal, including the algorithmic tools that it's used. But that's not the same as actively soliciting that public engagement. The requirement is a passive one. And so if the public can't afford or is otherwise absent from an important rule that affects the public and involves algorithmic tools, it's assumed that the public doesn't care. more perverse, the more education and outreach agencies do for the public to bring them in, the more comments they have to respond to, the more litigation threats they face. And quite frankly, from the standpoint of judicial review, the fact that they did all that extra work is not only not rewarded, it's irrelevant. All that matters on judicial review are industry challenges, or whatever the challenges are, and the court's decision about whether the agencies responded adequately to those finite listed concerns about the agency's proposal. So there's quite a few other perverse incentives hardwired in to administrative law as practiced on the ground, and they all point really to the same concern. There's a danger that for technical rules, particularly ones that are bringing in these complicated algorithmic tools, that an agency is going to find it most expedient to effectively negotiate the algorithmic tool as well as the rule itself with the highest stakes, most litigious groups. And they're going to do that first. So in these worst case scenarios, which we have seen in the past with computational models, the public may not only be left out of all the key choices that went into deciding whether and how to build that tool, but instead their role is really relegated to a very hollow opportunity of the ability to comment on essentially an inscrutable decision. All right, last slide. So what are some solutions? That is actually what motivated us to kind of put this paper together. And as I think I've hopefully made clear, these are not new problems to administrative law, but our concern in this paper is how complex algorithmic tools are going to make this situation much, much worse. So we conclude with a laundry list of suggestions, but just to highlight a few. The first is, are there ways to remodel or renovate administrative law to reward agencies for following best practices? So if an agency can demonstrate that it did involve the general public, it solicited their engagement at key points, including whether to use a tool, how to develop the tool, following best practices, the idea is the agency would get a reward, and that reward would be increased judicial deference. The courts would back off once they see the agency can show just how rigorous democratically those deliberations over complicated rules actually were. Some other possibilities, familiar, I think, to many in this group, subsidizing, obviously, public engagement, making sure and tracking that it's occurring, and if it isn't, having signals, and also maybe instituting ombudsmen or proxy advocates on behalf of the public to make sure they're represented. We also suggest that if private algorithmic tools are used in agency rulemakings, we need added protection, particularly if they're proprietary, but even without that, including perhaps giving public subsidies to public interest groups in academia to develop competing alternative algorithmic tools. Finally, this is an area for which we need continued study. There's a fabulous ACUS report. We suggest this kind of work needs to continue in real time to track what the agencies are doing. So in sum, the administrative state, I think, offers actually some of the very best opportunities for the public to make good use of algorithmic tools. But to make sure that happens correctly, I think there's some significant remodeling work that needs to be done. Thank you.
Thank you very much, Wendy. 3 extremely rich papers, chapters of this forthcoming volume. I can already tell that this is going to have a very long shelf life. 3 papers that don't necessarily overlap completely in the Venn diagram. And so for the next hour, our job is to figure out how they overlap. And we are guided on that journey by a really good trailblazer to lead us, Margot Kaminsky. She is our discussant and a professor at the University of Colorado School of Law. She specializes in the law of new technologies, focusing on information governance, privacy, and freedom of expression. Margot?
Thank you so much. Thank you, Paul. And thank you to our panelists. I am actually not going to spend time in the short time that I have summarizing what the panelists have said. Instead, I'm going to add some groundwork for what I hope will be a contextualizing and fruitful conversation starter. So my comments today are structured around 2 categories. The first is that we can and even should at least be looking to Europe as a model. I know that will start some productive conversation. And that's because the EU's General Data Protection Regulation has been practically spurring copycats around the world, and even to some extent, copycats within the United States. Even if you don't believe that the GDPR is functional regulation, its failures may teach us something as well. The second set of comments that I would like to give have to do with connecting algorithmic accountability to designing a system of oversight that includes serious conversations about tailoring transparency. I believe that administrative law is a great place to situate this conversation, as it's not new at all to that particular field, and that each of our participants today is actually talking about the relationship between information flow as designed in systemic governance and state power versus stakeholder power. So to start with GDPR, I'm tasking myself with the impossible goal of teaching a very complex regulatory system to a lay audience in around 2 minutes. The General Data Protection Regulation applies to automated decision-making, or what one might call AI, that uses personal data. So the kind of environmental policy tools that Wendy and Martin are discussing would not trigger this regulation, to be clear. GDPR applies both to the private sector and to government. So it does actually function as an overlay over individual European member states' administrative law. Now, my caveat as I discuss what the GDPR actually does is that my interpretation of it is an interpretation, and it's gleaned both from the hard law text of the regulation and from soft law, that is regulatory guidance. The GDPR has 2 tracks. It has a set of individual rights over the use of personal data, and it has a much ignored by US audiences system of systemic oversight that I think can be very useful for our conversation today. The individual rights that are granted in the GDPR include an access to data, an ability to correct personal data that's incorrect, abilities in some contexts to object to data processing, and for automated decision-making, or AI in particular, an ability to contest an automated decision. It also, as mentioned, includes systemic regulatory oversight measures, some of which might be useful tools for us to be discussing. The GDPR's guidance on automated decision-making suggests that we allow auditing of automated decision-making tools, that we build in expert boards and to consult early on in the design of these systems, that companies have recording requirements that in fact applies across all kinds of data processing to record the sort of decisions they're making as they build and deploy tools. Companies have a system of corporate responsibility in place, including many of them having a data protection officer. And what I would like to talk about at a little more length today, that companies that are using automated decision-making, and I should also say government entities that are using automated decision-making, deploy impact assessments. The impact assessment as a tool is something that we're seeing proposed in the United States, and then is modeled actually originally on US environmental law. So the individual rights are largely ex post. They happen after decisions are made. And the systemic regulatory oversight is largely ex ante, or contemporaneous with the design of the decision-making system. I've argued elsewhere that there are benefits to such a 2-pronged system, including that it echoes what we see in the best of US administrative law, and that these individual rights aspects go to essential qualities of dignity and legitimacy of a governance system, which can be missed if you focus solely on systemic measures. So some lessons specific to this conversation and our panelists. To Frank and his paper, I don't think it's fair, and I have others who agree with me, or accurate to describe the GDPR as consent-based. Instead, the GDPR creates individual rights that follow the data, that, like the chain link confidentiality idea you discussed in the paper, in fact, are unwaivable and travel down with data as it gets passed from entity to entity. So we may also want to be thinking about what individual rights we'd want attached to data processing or decision-making, and how we might make them effectively unwaivable. The second point to Frank is that data protection actually has an extensive history of ex-ante licensing. So the principle of data protection in the EU is that you can't process personal data unless you fall into an exception. And historically, several different member states actually had a regulatory body that would approve the proposal by a company or by an administrative agency to process personal data. It's effectively what you describe as happening in the Data Act, although it's was much more standards-based than rules-based. So this brings me to the tool of impact assessments. Impact assessments, algorithmic impact assessments, or AI impact assessments, has been much discussed recently, including in policy proposals in both the United States on the federal level and on the state level, and in other countries such as Canada. Andrew Selps, Sonia Katyal have discussed it in the literature here, and they model it on the idea of an environmental impact statement as mandated by NEPA. It also takes on elements of human rights impact assessments and privacy impact assessments, which are existing tools in other entities around the world. The best case scenario of an impact assessment is that it requires the user of an AI or an algorithmic decision-making system to assess systemic risk ex ante, to consult a group of experts and stakeholders, to mitigate risks, and to have ongoing evaluations, including evaluations by third parties. The worst case scenario, and what's often used to criticize the environmental impact statement system, is that an impact assessment can become a mere compliance checklist or a rubber stamp for behavior without changing it. So now turning to what I think is the broader framework for our panelists' contributions and papers, algorithmic accountability is about tailoring a system of governance. And that includes tailoring transparency, which means designing clearly what information goes to whom, why, and when. And impact assessments might be part of this picture, as might other measures of systemic oversight, such as the licensing system, as might other individual flows of information, such as giving information to criminal defendants when you also give that information to prosecutors. But any one tool is probably not alone going to be enough. It's about system design. So for example, if I want to enable an individual person to contest a specific AI decision involving her personal data, it needs to be explained to her and accessible to her in a way she understands and can contest. Whereas if I want to enable an expert to do a deep query of a model, I would be opening up a different kind of information flow of highly technical information at a different time before the system has been built to different people. So wrapping up, as Wendy and Martin point out, how to tailor transparency and design accountability is hardly a new question in administrative law. The historic goals of administrative law are to channel expertise while preserving democratic legitimacy, which requires a very complex blend of keeping information contained while also allowing information flow in and out of that system. This might possibly be new in some ways, in some more limited ways, as a conversation when we're talking about it with respect to artificial intelligence or automated decision-making, because as many people on this panel and elsewhere have noticed, those systems can be black box in a technical way. You can experience expertise resource asymmetries because some of these systems are developed privately as opposed to within the context of government. And for helpful related discussions for this panel, I would recommend looking to Daniel Citron and Ryan Kalo's The Automated Administrative State, and to Deirdre Mulligan and Kenneth Bamberger's Procurement as Policy, both of which discuss other elements of these concerns. So I'll close with observing some contributions from the panelists and what they add to existing conversation. 1, as Wendy and Martin point out, information is power. And we need to look out for how we are setting up the ability of private actors to game and exacerbate asymmetries versus solving those asymmetries through creating information flows. This includes figuring out whether we need to have government make affirmative actions, such as paying for expertise or providing expertise, for less resource stakeholders, including NGOs. As Rebecca points out, the problem is not just creating information flows, but also looking to what information flows we don't create and what asymmetries we create when information goes to one stakeholder, but not to an opposing stakeholder. So when we create an information flow, who isn't at the table is an extremely important question to be asking to drive conversation. And then this is an extremely granular response to Frank. But to Frank, with licensing, his proposal and the Data Act actually raise a really interesting contrast to what we do in Europe, or what is done in Europe, which is again an element of institutional design. So as the Data Act proposes licensing data processing, the ex-ante rules that are listed are very specific. There's only very specific context in which one can process data. In Europe, they have chosen to do instead a much more standard-like approach using the legitimate interest prong, which means that if you can show a legitimate interest in Europe, then you can process data, personal data. But that's fleshed out in guidance, so it's not entirely some vague standard. So I look forward to talking further with our panelists and with the questions that are posed throughout this session to hone a little bit more on how the pieces fit together as elements of systemic design. Thank you.
Thank you, everyone. I will now invite all of our speakers, including Martin, who hasn't had a chance yet, to join me on stage. We have 45 minutes to talk about an unusually rich trio of papers, and Margot's interventions only kind of heightened, for me, the excitement of trying to find the interconnections and the themes. I want to roughly split that in half. We have 4 fantastic questions in the queue, admittedly 3 from one very involved and astute questioner, and I encourage more of you to submit your questions. But as I said, we'll take the moderator's prerogative and try and ask a few questions in the beginning. I'm going to not do what would be obvious at this moment and give you all 5 more minutes to respond to all of the kind of wonderful interventions that Margot put on your plate. If you want to do that in response to any of my questions, please feel free, because she directed a lot of really incisive and insightful things at all of you. So I'm going to start at a really, really obvious place. I'm going to play to my stereotype, right? Which is, I was astonished how rarely the word privacy was uttered in these papers and in this panel. The title of our panel is Data, Publicity, and Public Control, which is such a kind of Orwellian way of avoiding saying the word privacy, maybe. Sorry to my, my night inviters, I'm not accusing you of being Orwellian. And I think privacy is this kind of interesting tension that runs throughout the 3 papers and Margot's comments as well. And for those of you who don't kind of get deep in the weeds of who does what, right? Margot, Frank, Rebecca, and I think largely call ourselves privacy scholars, but increasingly artificial intelligence scholars. And so I want to start with the non-privacy scholars, at least by label, Wendy and Martin. So Margot said something that I was thinking while I read your paper as well, and I'm not sure it's right, which is maybe even people who worry about privacy can worry less about the kind of data analysis that as at issue in your paper, because after all, it's mostly about kind of quantities of carbon in the atmosphere, industrial systems. You know, we're measuring corporations, and we can put to the side whether corporations are people who have privacy, unless you want to go down that road. Does that strike you as right? Either one of you, does that strike you as a reason why, if there are privacy activists who are really worried about artificial intelligence, they don't really have to pay attention to the problems you're discussing, either in this paper or in your broader body of work, because you just want to measure cows and machines, right? To really oversimplify.
Yeah, no, I think, you know, it depends on how you slice sort of what our paper is offering. So I think at a very grounded level, obviously, we're focusing on environmental and public health regulation because we wanted to get somewhere within this huge administrative state. But we don't have the data or the ability to extrapolate from what we see in public health and environment to other areas. For example, sort of the regulation of privacy by, is it FCC?
Well, the Federal Trade Commission, right, helps administrate.
Yeah, and how they administratively sort of enter into that area. But I imagine there's a lot of carryovers in the sort of problems that we see in terms of ex-ante regulation and designing ex-ante regulation that go well beyond, you know, sort of cows. But I don't know if that responds to your question.
No, it does. I mean, and you're right. When you bring public health into it, especially, I mean, I focus more on the environmental part of your work. Public health, right? We're living in this kind of COVID time when we're seeing real tension between personal privacy, kind of toothless laws like HIPAA, and then efforts to bring us back to our ordinary lives. So obviously the question I had doesn't make as much sense if we're talking about that. But Frank's examples are all about kind of individuals and what happens to individuals, and your examples are not. And so it struck me as, you know, your main example is about the side effects of particular chemicals, right? Which seems to be a little bit less about individuals than the other. And I was wondering if it's a way to square the 2 papers or have them talk to one another. Yeah, go ahead, Wendy.
No, I mean, I think, yeah, absolutely. Ours is looking sort of more abstractly and cumulatively. And at least in the focus of our paper, we aren't seeing much going on with regard to privacy. In fact, usually the research that the agencies use has a lot of protections for privacy, if it's epidemiology studies, for example.
Yeah, and so maybe a question to Frank and then Margot. which is a variation on the theme, right? So is my critique of the title of this panel fair? Or are we in a kind of moment where old discourse around privacy is not productive? That when we're thinking about platform power or power generally or democracy and data, that privacy should be relegated to kind of, the yesteryears. That's what we used to worry about, but we're sort of in a post-privacy age. Because again, of the three papers, Frank, I think yours is the only one that seemed like a kind of, at least in conversation with privacy in a super, super deep way. And so maybe we're kind of old timers that need to get with the program. What do you think, Frank? This is becoming a counseling session between you and me.
No, I do think that it's very valuable to be thinking about the type of path dependency that different regulatory systems get set upon, given that, say, a certain type of regulator takes it over, or that as a problem is defined as in a certain way that highlights some aspects of the problem, but doesn't highlight others, right? So in my work in the privacy, confidentiality, and security, you already see that, right? We don't say we're the privacy committee for NCVHS. We include confidentiality and security in part because we realize that, like, privacy, it's not capacious enough to really identify the values and interests in all those areas. And I think that sort of would be a fascinating study, Paul, to sort of think about this path dependency idea. I know there's some critiques of the Federal Trade Commission as an entrepreneur that sort of took over privacy as one of its big concerns in the 90s. And there's speculation on what are the paths not taken if we had a separate privacy agency, and now there are entities saying we need one, right? We're saying that there have just been so many problems with the FTC regulation. It just seems so toothless in so many ways that we need a whole different regulatory entity. And so I think that that's a very good question. And I think that, in the future, I try to use the word data protection more, but I also think that there's a way in which in the future, perhaps the sort of AI algorithmic law may end up, rather than being a subfield of privacy law, may end up being the more capacious category that sort of brings privacy law within it. Of course, aspects of it, because as we all know from the seminal work in privacy, there's like 14 different types of privacy in Dan Solov's book, and others. So, but I'm just talking primarily about data. So, yeah.
So with apologies to those who think this is just needless navel gazing, I'm going to continue to peer into the dark chasm that is my navel. So Margot, is this post-privacy? I mean, with Frank, you and me, I think we have a quorum. We could just close up the field today and vow never to use that word again. It's all data protection, power, data, and democracy going forward. What do you think?
Paul, I am disappointed with your narrow and outdated definition of privacy. So information privacy, as I understand it, or at least information privacy governance, is fundamentally about accountability. The Fair Information Practice Principles, which date back to a US government document released in 1973, include fundamental open government principles, such as allowing access to information, allowing the ability to basically get your file that the government holds on you. And the California Consumer Privacy Act, the CCPA, is in fact fundamentally a transparency law. It's again about seeing the information flows and figuring out, where your personal information is going, and really doesn't have much in the way, there's the do not sell portion, but there's not much in the way in the original law of actually stopping information flow. And as a note of cautious optimism, to speak to what Frank raised in his paper about concerns about First Amendment challenges to data governance, I think that emphasizing that privacy laws are in fact fundamentally about transparency and accountability allows us to create a more comfortable fit between privacy governance and data governance, and perhaps strategically deployed First Amendment challenges to such governance regimes.
Great. And lest Rebecca think I'm going to spare her from this silly line of questioning, Rebecca, I have a question for you about privacy and the role it plays in your paper. You know this about me. I love your work, but I feel a little personally threatened by it because you now have a trilogy of papers that in a quite compelling way argue that the Stored Communications Act, which is the kind of thing I bring to me at night and read in bed, which is one of the rare examples of Congress enacting meaningful privacy protection for individuals in the form of our stored communications, should be cut back, and should be cut back for important purposes like access to data by criminal defendants. And that worries me. And I wonder if, again, I'm going to do this in a navel-gazing way. I'm sorry. I wonder if you might consider yourself sort of an anti-privacy scholar. That what you're doing in such an interesting and compelling way through a series of papers, and I'm starting to see a trend line, is talking about how privacy may have gone too far, how it hurts people who really need our help, like criminal defendants. I will note that the kind of recipient of the subpoena in the example you kept giving was GitHub, which is Microsoft, right? But you can replace that with individual human being who has an email account. Your arguments would kind of reveal their email as well. So that's the privacy thread that I think your example elided a little bit. But what do you think about that? Are you ready to declare yourself the anti-privacy scholar in our field? You might get a lot of attention by doing that.
So thank you, Paul. And I don't mean to threaten anybody's statute or identity, certainly not the field of privacy. I would resist that characterization. I think one of the concerns is that as privacy has become a powerful term that can move objects, more people want to claim it. And they want to claim it for things that really aren't part of the justified, legitimate privacy interest. And so I think it's actually a defense of privacy to say we need to identify where it's properly limited so that we can have a fair and balanced privacy policy. In terms of the Stored Communications Act, I have a concrete answer for you and then a broader one. So I'll start with the broader one, which is that construing silence in the SCA or in the Cloud Act to permit defense subpoenas is not erasing privacy protections for individuals. It just means the statute opens onto the baseline procedural privacy protections that are already built into the criminal procedure rules. So the same types of privacy protections that subpoenas right now apply to a victim's mental health records will apply to the contents of your email or to GitHub source code. But what those baseline standards do is allow some weighing of the interests rather than a categorical grant of immunity that allows a company like GitHub, or we can call it Microsoft, to slip its own economic interests, going back to the LPE framework, into the public proceeding of the criminal legal system. The concrete answer is that over the summer, the California Supreme Court issued an opinion in a case called Touchstone that suggests they are seriously considering solving the conflict between these data privacy laws for the internet and criminal defense rights by reading any tech company that relies on a data-driven business model out of the coverage of the SCA and the Cloud Act entirely, or that part of the Cloud Act entirely. So the options on the table right now for solving the conflict with defense rights are either we have no Stored Communications Act for most of our tech companies, or we simply construe statutory silence to do something that there's every indication Congress intended at the beginning, which is to yield to criminal defense rights.
So then let me ask you a quick follow-up, and it might be a way to invite Wendy and Martin back in. I mean, I think what you just said was, we don't necessarily need a relatively new statutory scheme to deal with this because we have this thick layer of historical privacy rules. But, and it's similar to what I heard some of what Wendy was saying, which is we're not reinventing the wheel here. We should learn and not give up on what we've developed through 100 years or more of the administrative state and adapt it. The counter to both of those arguments is that a tech exceptionalism argument, right? That I don't want to rely on 100-year-old criminal procedure laws that were created in a different time with different communications media, especially if Congress, in one of its rare productive moments, intervened and brought the law up to date. In your earlier landmark paper, which is now in the Harvard Law Review about this, you had this wonderful disquisition on the law of the privacy of telegrams, right? And one argument is, well, maybe telegram law ain't what we should be looking at maybe we shouldn't make privacy great again, but instead we should kind of allow new legislatures and new modes of legislating around privacy. And Wendy, I want you to take on that same question when it comes to your recommendations. Rebecca?
So I'll just respond quickly and also connect it to what Margot, Frank, and Wendy were saying, which is I do believe that the ex post grant of data flow access to the criminally accused should apply as part of this broader systemic oversight that Margot talked about and that Frank and Wendy are talking about. So I don't in any way think that an individual right to contest for indigent criminal defendants is a exclusive solution that should supplant, administrative regulation or other oversight mechanisms. But what it does do that procurement policy expert audit bodies don't do is it allows us to catch the as applied errors in individual cases. And if we turn to forensics, which is, I think, a field that could contribute more to the conversation on AI and data privacy regulation than it has yet, we can see that there have been attempts to set standards, to have expert audits, and those have fantastically failed in the recent exposés of fraudulent forensics, hair fiber analysis, misconduct happening in the courts. So there's a combination need, and all these pieces can fit together.
So Martin and Wendy, similar question, is 100 years of administrative law enough? And we should turn the page because of the tech exceptionalist critique, that there's something about specifically machine learning, which is what gets a lot of attention in your paper, that is going to just subvert all of these old mechanisms, and that we're better off starting from scratch?
I think the context is totally different. Now data is centralized. Basically, all of us, including the platform we're using for communications, is centralized. For the last 20 years, sort of against the initial dream or romantic ideal of the internet used to be. In terms of the subject by Rebecca, easily there could be Innocence Project like lawyer who carries out a data breach to a centralized data server in order to access the information that's not available to regulation or to licensing. So this can be an example on how the lack of transparency, lack of regulation could threaten privacy, because that data breach is going to expose the data of millions of people. Correct? It's going to serve its purpose, but it's going to be a loophole. Now, that's carried out in a context in which civil society is highly empowered. Most of the platforms we're using are open source. Linux operating system is open source. It was carried out by people not being paid. So civil society has a high knowledge, and not only civil society, but nation states, advocacy groups, and so on. One example is the Panama Papers. It's a very example. Panama Papers has been an unprecedented data breach, which held accountable to more than 32 high-ranking officials in ways that proactive data availability, proactive coming from the states, was not able to do it. So from my point of view, we live in an ecosystem that's sort of self-healing, in which if we don't provide the appropriate rules, regulations, then the civil society is going to take care of it, because it's highly empowered. Information is centralized. So the recommendations we provide with Wendy are of course kind of very old, 50 years ago. NAS was very wise in providing very chapters and books about what was the context then. However, now we live in a totally different context, and I believe a lot of things need to be rethought. Well, thank you.
Wendy, I don't know if you have I want to turn to the audience questions soon. Do you have a brief addition to
Sure.
that? Or?
No, I think it's a great question, Paul, and obviously something we struggle with whenever we do these kinds of papers. And I love the idea of just rebooting the whole thing. I think in the case of administrative law, which isn't quite 100 years old, but it's old, it would be really premature based on the very limited uses of AI we see coming down the pike now to sort of say we need to reboot administrative law. But what I do love about your question is I think AI, as we show in our paper, I hope, really causes us to want to reconceptualize what this whole administrative state is about and helps us see, at least in the abstract, how it's falling short in the past and is likely to get worse in the future. But what that means for reform may not be resetting the entire law and regulation. Instead, it's making a much clearer goal of what we're after in our legal design and then adjusting and tweaking things to get there instead of sort of rebooting everything, making sort of adjustments. But it's fun to think about starting over.
The way we're gonna get into audience questions is I'm gonna ask Frank one more question, but while I'm asking and he's answering, I'm gonna ask Margot to look at the very good question from Judith Rauhofer, which goes a little bit in the weeds of the GDPR. And so this is my way of not having to butcher it and have you restate the question and then answer it. She has two questions actually, but Frank, the other thread I see through Wendy and Rebecca's paper that you don't take on as directly is the problem of power and money in ultimately deciding who gets to set the rules, right? I mean, that's pervasive in what Wendy is saying especially. And she, you know, as others have, is proposing funding NGOs so they can kind of compete with the corporate interests. And so that's one concern I have about licensure. I actually am super intrigued by licensure. I think we didn't give you enough time. I wouldn't mind if you just spent a minute giving us a clear vision of how licensure would work out and how it might differ from Sherrod Brown's proposal. But along the way, can you talk about whether that's just totally subject to capture, that licensure is just going to kind of be a way for the most powerful and the wealthiest to hoard all the data in a sort of anti-competitive way. And the people who will be excluded will be the rest of us, right? The people who cannot compete because of the kind of administrative difficulties that Wendy talks about. You're muted, Frank.
Yes,
yeah.
I was, I had a too fast a fat finger error, I guess we call it. So this is, I think that, you know, this clearly, yes, we want to think about the capture problem and we want to think about the substantive basis of licensing. And in terms of, you know, the idea of the GDPR here, and I really look forward to looking at reviewing the historical materials and the other materials that Margot recommended with respect to some of the ex-ante approaches that were taken there. I think that the main idea here is to have perhaps a core of things that we're very worried about being misused. And there again, I would go back to my old colleague, Danielle Citron's article, Reservoirs of Danger, where she describes the accumulation of massive amounts of data as being similar to the tort law should learn about from the accumulation of massive amounts of water, where there were forms of liability and then regulation that would essentially keep you from perhaps living downstream of someone that had a massive reservoir, and similarly that could keep you from being potentially victimized by someone that, you know, accumulated tons of data but without properly securing it. And I think the similar types of issues come up with respect to those issues of that I mentioned with respect to analysis and use. But I think that, you know, if you were to think about like what would be the substantive foundations of the licensing principles, we could look at the permissible interest sort of tests and other tests from the GDPR. We could look at the 12 types of examples that were given in Sherrod Brown's Act, which the Data Act, which I won't belabor all 12 of them, but I think that there are definite forms in there that are meant to protect exactly the sort of core journalistic, educational, research, other sorts of endeavors that we'd all agree are quite worthy of being privy to such data. So those are some initial steps there. The capture argument, I think, is very interesting, and I'm working on that. And I think my most aggressive response to that would say that I think that to the extent that many jurisdictions are worried about the rise of abusive, authoritarian, or even fascistic leaders, to some extent this has been exacerbated by what I would call a Wild West regime of both media and data regulation. And I think that we have to think about the chicken and the egg. We have to think about to what extent if we're in the position where we distrust government so much that we don't think that it's even capable of making fair-minded decisions with respect to, say, ex-ante licensing, watching out for data breaches, then perhaps we've done something so deeply wrong in the past that we can learn from that as being the wrong, as opposed to the proposal that I'm putting on the table. But it is a very important question.
And correct me if I'm wrong, but it's such a provocative argument, and I think we haven't had just a plain description of it. I mean, you literally are saying, and I think I want to repeat it just in case Adam Thierer ever watches this, just to watch his head explode. You are literally saying, in one version of this, if you want to use, collect, disclose 2,000 records or more about personal, individuals, you need to ask the government for permission first. Is that just like too bad a caricature, and it kind of butchers what's important about your proposal?
I mentioned in the talk a footnote that was referring to the 2014 paper that gave 2,000. The talk itself has 10,000, or the paper itself has 10,000, so factor of 5.
But some number less than all of the data, right? Yeah, right.
And then when someone comes at me, from say a libertarian angle, corporate funded angle, whatever the angle might be, and says to me, "Hey, that's absurd. That seems so deeply offensive to my notion of fair play and to how things should be structured," I can say back, "Okay, let's make it 500,000. Let's make it 1 million. Let's make it 10 million. So we can play this game. We can sort of play the game of saying that we only recognize libertarian principles as being deontologically prior to all other social values. Or we can play my game, which is to say, well, I'll just keep upping that number, and then maybe we'll be able to come to some sort of social consensus. I think that ultimately my way is an approach that is a foundation for democracy because it enables dialogue about exactly these types of difficult issues. Whereas the more deontological approach that looks at things and calls proposals like mine prior restraint or impossible to imagine or something, that's something that I think is more authoritarian because it essentially says, fiat justitia ruat caelum, let there be justice, let there be my notion of justice, be it Herbert Spencer's social statics or what have you, or let the sky fall.
Thank you. And again, I think that'll probably inspire even more audience questions. We have an even dozen. Let's turn to those. And Margot, I did mean what I said. It actually connects well with what Frank was just talking about, because I think Judith's question, and again, I'm not a GDPR expert, gets to your claims about ex ante versus ex post.
That's correct. So yeah, I'm going to try to do some translating. And this is not because Judith asked an unclear question. It's because US audiences are just very unversed in understanding a lot of the vocabulary around GDPR. Judith, this question is excellent. So let me go back and describe a little bit, again, what I claimed, which is that the European system of data protection actually has origins in some member states in a system of ex-ante licensing, which is exactly what Frank is asking us to consider doing. So some member states did almost exactly what Frank is calling for back in the 1970s before there was EU-wide data protection law. And they would tell companies, if you're processing personal data, and this wasn't large amounts of personal data, it was processing personal data, full stop, you have to come to the state for approval. And the way that you do this is by coming and describing what the processing is within a regulatory constraint of what kinds of processing is allowed. So the sort of follow-up to that is this notion of, that's currently in the GDPR, of the impact assessment, which is that the European system no longer says you cannot process data unless you come and give us this complex assessment of how your data processing is legitimate. Instead, it creates a series of listed exceptions. And as Judith points out, largely companies are able, and again, administrative agencies are able to say, I fall into an exception, and nobody comes to look at them knocking on their door to make sure that is the case. And the impact assessment is supposed to be part of the system of self-created accountability which is to say the company or the administrative agency is supposed to be conducting the same kind of assessment of its processing that it would have under these old laws. But again, largely nobody's coming and knocking and making sure that they're doing that. I think the epitome of this is that the impact assessment in the GDPR is not overseen by a regulator, and it's not required to be released to the public. It can be voluntarily released to the public. And if a processor decides that they're conducting high risk processing, themselves decide that, then they have to go talk to a regulator. So to Judith's really important question, which is practically, even though this looks like an ex-ante system, because of its emphasis on self-directed accountability, it's actually very much ex post. And you have these regulators in Europe who, I think is a very valid critique of the GDPR, don't enforce it. And so this brings me back to the US. I'm hedging on Judith's specific question. You're in the European context and bringing it back to the US conversation to say there are two lessons we should be talking about here. One is that we need to have the transparency and accountability conversations about the regulators too. So if we have a lax regulator or a regulator that's likely to be captured, we need information flows about that regulator's decision, not just information flows about the design of the technology. We need to regulate the regulator and open that up to public accountability. The second is to emphasize the importance of the private cause of action debate in the United States around privacy laws, which is that if you have a limited capacity regulator or a regulator that is likely to be light touch, you can't rely on these forms of self-accountability. And we have some great class action systems in the United States, or at least somewhat have those. And so the private cause of action is a way to try to get around the light touch or reluctant regulator.
I mean, that one obvious, or not obvious, but one follow-up, Wendy and Martin, is I'm going to reveal what I don't understand about administrative law, which is I'm going to reveal some of what I don't. So I was worried about one part of your paper where you propose kind of super deference from judicial review if you impose a few more accountability regimes. That, especially when coupled with concerns about capture, really worried me. I mean, it seems like, as I think part of what Margot was saying, is we should regulate the regulators. We need more scrutiny on what they're doing, and more accountability, and more political pressure. And I'm a little worried that super deference goes the other direction, unless I'm totally misunderstanding that part of the proposal.
No, I would like to, I guess, add to the proposal in terms of what it entails. So the idea of a super deference is essentially it's like an affirmative defense. The agency is prepared not to get deference, and they show the court in detailed, rigorous ways that are communicated beautifully just how excellent they did engaging the public. So all of a sudden, the agency has strong incentives to communicate the rigor of their democratic deliberations. So that may be slightly different from what you were thinking of. It is dicey, but the idea is if this worked, then the court would say the political process is engaged. Even though we don't love what the agency did, it's now visible. It's now out in the open for the political process essentially to take the disciplining. And I guess on this European Act, the regulating the regulator sounds good. I'm not exactly sure how you do it. And honestly, the more I hear about that, it sounds like maybe some rebooting of the entire process would be needed, in terms of how the exceptions work. I like the idea of ex post sanctions with private litigation, but I think sometimes the problems in these regimes is that nobody has the incentives to communicate clearly what they're doing, particularly the agency. And the more that flies under the radar, the happier the main participants are. And so, at least in our view of administrative law, we're trying to bring out incentives to do a good job and communicate that. But maybe in Europe, that kind of thinking could help, maybe more than trying to regulate regulators.
Does anyone else want to jump in on the GDPR before we turn to lots of other questions? So don't feel obligated. All right. The next question is inspired by this question from Kyle Jacobson, and his brother-in-law was a student of yours, Wendy, and he notes that in the question. Again, I'm a privacy scholar. I'm not sure I'm supposed to read that to all of you, but he talks about transparency as a way to discipline kind of algorithmic accountability. And I know every panelist here has written significant works about transparency, particularly how it overlaps with AI. And in your piece, and this goes to Martin as well, you have this phrase that I hadn't seen before, but maybe I just don't know the literature well enough, which is fishbowl transparency. Right? It's not just transparency, it's fishbowl transparency. So I want you to explain what that means, and I'm interested in Martin's thoughts as well, but I also want to know why transparency is an important part of the answer, why it really is a meaningful way to figure out what a machine learning algorithm specifically is doing. And forget about machine learning algorithm, machine learning model, or machine learning system, or machine learning universe, right? Pick the analogy you want. Why any increase of transparency is going to help us at all with the kind of, fundamental concerns that we have. So.
Great. So Mark, should I get started and then you can jump in? Yeah, and I think you can unmute at the same time. We can talk over each other, particularly when I'm being ridiculous. So actually, I think in our paper, so fishbowl transparency is a term by Carrie Coglianese. And I think that seems to be what Rebecca is essentially advocating in a way. Access to information, I don't know. And when Margaret talks about information flows, I hear a lot of sense of access to information, which is what I use, information transparency, access to information. So in our paper, I actually think we do think that's important. So I would agree with Kyle's question, but most of the emphasis on our paper is on the second problem, namely the difficulty of making all this information actually meaningful or accessible in ways that people can engage with. And in administrative law, that's the problem. We actually have really pretty good transparency, not on all algorithmic that are proprietary models, but we actually have really good transparency, and the agency's very good at literally having 6 file cabinets of information up on the internet for public stakeholders to look at if they have the time and resources. So I think equally important, maybe more important ingredient to designing a system is not only to have the access to information, but ensure that the audience who needs to use that information is capable of using it. So I think that's what we were trying to say. Martin, did you want to throw anything else in there?
Yeah, and I want to, before Martin goes, I rarely like to ask one question and have every panelist answer it, but I think this is a fundamental one. And I think I want to hear what Margot, Frank, and Rebecca as well think about transparency when it comes to machine learning specifically, or artificial intelligence. And should we continue to embrace that? I think it's part of what Margot was saying about impact assessments a little bit, or maybe not. But Martin, why don't you start?
Yeah, thank you. I look at fishbowl transparency or data availability or algorithmic availability, make it public as the tip of the iceberg. As Frank alluded to, and there is another author also that presented on the issue, we have to look at the issue from the systems perspective. It's only the tip of the iceberg. However, we need to have provenance. I mean, we need to ask which stakeholders took part to produce this data, to produce this algorithm. What was the reason they made this specific choice? This issue is important because a lot of products we're going to see in the AI area are going to be black box. Basically, they are going to be contracted to other companies. We're not going to be able to see the code, but we should be able to ask a question: why was this specific vendor contracted? How can we test the systems? Which are the inputs and the outputs? Who in the agency decided that this specific contractor will be contracted? And there is with the partnerships, correct? And so transparency, it's a very big area. It's not necessarily data availability. And something important we need to remember is somebody said information is power. Yeah, information is power, but we need to transform data into information. Right now, we are basically clouded with immense amounts of data. But interestingly enough, AI is not being used to make such data meaningful to the citizenry. By instance, the ACRUS report, I don't see any agency using AI to make data meaningful. to make smart types of visualizations or other types of outputs. So, so just making data available, I don't believe it's transparency. There needs to be another stage which data needs to be translated into information. And if we don't do that, and that's what misinformation and disinformation takes place. Thank you.
In our field, if you say the words black box, Frank appears, and so it's a good thing he's already here. That would have been really confusing. So Frank, why don't we go to you next? You've actually had a journey in your scholarship about your relationship to transparency. In some of your earlier works on accountability, transparency played a huge role, right? And I think you were associated with ideas of just hand over the source code and we'll know what you're doing. Maybe that's an unfair characterization.
No,
where are you today? Where are you today on this?
Well, I mean, it depends on the area. And I'll say very quickly about my scholarly journey, but then I want to shout out two other brilliant scholars that I wanted to just recommend to everyone. And in my journey in scholarship-wise, when I wrote Black Box Society, chapter 4 is all about finance. And it was all about making things transparent, you know, inspired by like Henry Hu's work about transparency and the ultimate function of the disclosure ideal at the SEC. I recently published a piece called A Rule of Persons, Not Machines, where I'm as I look more deeply into the difficulty, I find it very difficult to say that you could make a lot of these algorithmic arrangements transparent. But that doesn't mean that I necessarily just bless them. I think the transparency emphasis is sometimes misguided. Now to get to the scholars that I want to recommend on exactly the topic you're bringing up, Paul, and machine learning, AI, and its role in law when it's not transparent. The political philosopher Dan McQuillan has made the point, I think very strongly, that machine learning is bound up in particular data sets, particular practices, particular ways of coding things that could be otherwise. And so in that respect, it is fundamentally contestable. The question then becomes for lawyers, how do we deal with this contestability? And one of the persons who I really admire her recent scholarship in this area, she's a former judge that then went to get a PhD in law, is Geneviève van der Stachel. And Geneviève has argued, or former Judge van der Stachel has argued, that essentially machine learning outputs are sui generis, okay? They're not law as we know it. They're not a court case. They're not a secondary source of law. There's something that's sui generis. And this nature of dealing with this fundamentally different thing in law requires much more reflection than I think it's really been given. And so as I'm working on a journal on computational research in law, or I'm one of the co-editors of that, one of the big questions we want to see from our submitters is how to deal with this sui generis nature of something that, you know, has sort of the patina of science and yet is so deeply imbricated in particular data sets and methods that it's very hard to think of it as true science or some true picture of reality.
I will say I should have given you all advance notice. I'm thoroughly enjoying the question and answer, but it does mean we're probably going to run out of time after Margot and then Rebecca go. So Margot, the same question to you: transparency, artificial intelligence, machine learning, and also, is it fair to say impact assessments are largely about transparency, or is that kind of beside the point?
No, completely unfair, but I'll come back to that. So transparency is necessary, but not sufficient. And I want to make 2 points on that. One is that there's a robust conversation in the EU, largely pushed by Lillian Edwards and Michael Veal, about the concept of transparency fallacies. So creating and I think it resonates a lot with Wendy's work here and elsewhere, that you create a disclosure regime, but the disclosure doesn't do anything because the people who receive the disclosure either never receive it or aren't empowered to do something with it. And that speaks also to some of what Kate Crawford has talked about, specifically in the machine learning space. So transparency necessary, but by itself not sufficient. The second point I want to make is that transparency, full public transparency, fishbowl transparency, Frank's earlier claims and others' earlier claims that we should release all the source code and release all the data, which is not precisely what he said, is a straw man in a lot of these arguments. And I wanted to point back to, I love being able to refer to my panelists' books, co-panelists' books, to the Black Box. I think it's also, I don't know if it's chapter 4, you'd know better than I would, Frank, where Frank discusses qualified transparency and the idea that this is about, so I keep saying information flows instead of transparency, because it is about creating flows of information that don't necessarily go fully to the public, that don't necessarily provide all information to all people, or filter is kind of a negative term, but uncurated information to all people, because sometimes what the criminal defendant needs, and Rebecca, I'm going to tee this up for you, might not be a data dump of everything in the data set. What they might need is for the relevant company to curate the information in some way that's relevant to the criminal defense process and actually gives the tools that are necessary to contest the use of that particular tool in that situation.
And Rebecca, you will have the last word, and Margot's right. I mean, it's not only in this paper, but the paper that brought your wonderful work to my attention was earlier work on the use of trade secrecy law to keep algorithms away from criminal defense lawyers as well. And so the kind of premise of both of your examples are, all we have to do is give them these algorithms and they will have the tools they need to acquit themselves. Is that right? Are they gonna, walk?
Thank you for teeing this up. When we talk about transparency, there are two elements. There is a right to secrecy versus a right to access. And the debate we've just been having is about what are the terms where access is useful or necessary. But we're omitting the issue of when does the law afford an entitlement to withhold? And it's that question that we as lawyers are responsible for. So if trade secret law does not include an entitlement as a matter of intellectual property to quash defense subpoenas, or if privacy laws do not include categorical immunity from defense subpoenas, then it's a very different equation to say, well, can we withhold this information if defendants request it? Now, there may be expert debates. There are expert debates, Paul saying AI, ML, what's the purpose of transparency here? And I'll say, let the experts fight that out. But when a court finds the information is necessary to the administration of justice, and there is no legal entitlement based on privacy or IP to withhold, then we should compel compliance. My last comment is just to say, when I was a law student, I got the Yale Law School to purchase the Black Box Society. And I had the amazing opportunity to be a law student with Margot Kaminsky as the executive director of the ISP and work, and Wendy and Martin, it's great to learn about your work, but it's such a privilege to be on a panel with so many of my intellectual heroes.
That is a wonderful, wonderful note to end on. We need happy thoughts like that in these bleak times. Before I ask you to join me in thanking the panel, when you speak of heroes, probably the biggest hero in my life is Julia Angwin, and she is your keynote speaker in about 10 minutes, which is why I wanted to end on time and cede the floor to her. But before I turn this back to Katie, let me just ask you all, wherever you are, we can't see you, but we'll feel the love. Please join me in thanking the panel for the wonderful job they did. Thank you, everyone.
Thank you all so much. And thank you, Paul, for that perfect transition. So we're just going to take a short break to get ready for Julia's keynote, but you are going to want to stick around. Go grab a cup of tea, grab a snack, and come right back here at 1:40. We're going to close the Zoom window, but you can get right back in with the same link at 1:40. So we'll see you soon.